First up, can I just start with the fact Australia has a thriving startup business sector here in this country. So if a notable one were to fail and end up in court, would a defence of we tried, we failed, it's not a crime, would that hold any water here in Australia?
So I'd have to say, Ross, that's not really a defence. And I'd have to say it's not really a defence under either US law or Australian law. But I can certainly understand why the defence attorney is arguing that from day one in the trial in California, because the defence attorney wants to create the right impression that what this is all about is a young, talented woman who worked hard, had a fantastic idea, and through no fault of her own, the company failed. But that's not really what the prosecution is arguing. They're basically arguing that she and also her deputy committed fraud.
Okay, so take me to that, because if a company fails in Australia, when the authorities go through to have a look, or the insolvency lawyers come through and have a look at that company, they will look to see whether there is culpability on behalf of directors or business owners. And so what are the types of things they typically will look at when a company fails in Australia?
Exactly. So it is absolutely important to note, Ross, that businesses fail all the time, and they can fail for very understandable reasons outside the control of the person who founded it. So that's not a crime, that's not an offence. But where do we see circumstances where our regulators start to get interested, as we see in this case in the United States, where in particular it's alleged that fraud was committed? In other words, what's being argued here is that from early on, the defendant here actually knew that the product was not what she said it was, and that then she deliberately, not negligently, deliberately misled who? Misled investors as they put in hundreds of millions of dollars, misled doctors, and also misled patients by saying that this product was in fact revolutionary when the evidence was growing and growing that it was not, according to the prosecution. So if we had something similar here in Australia, for example, in the case of offences, we could look at our laws, our Commonwealth laws, or even some of our state laws, which have provisions that say that it is actually a crime to give false or misleading statements that have the effect of getting people to invest in companies, in other words, where they're misled. So we have some similar laws here in Australia, if it can be shown that the company founder deliberately misled investors.
So explain the nuance of wire fraud in the United States versus what we have here in Australia, because obviously wire fraud is all about the transmission of information or a phone call or whatever it might be, and it seems that that's a fairly frequently used prosecution in the United States. Why do we not have something similar here in Australia? In one sense, we don't really need it because in the United States, the reason they're using wire fraud defined very broadly, it would include things such as advertisements that cross state borders and allow the prosecution then to establish what we would call a nexus between the defendant, the conduct of the defendant, and where the recipients of the misleading information are actually located. Now here, to the extent to which our prosecutors use Commonwealth law, such as, for example, Section 1041E of our Corporations Act, which is Commonwealth legislation, that can cross state borders, so that someone could make a false or misleading statement in Sydney or Melbourne, say, Ross, and the fact that the recipient of that is in Tasmania or WA doesn't make any difference. And you can make that statement in all sorts of ways under Australian law. So we don't need that technical word of wire fraud. You could make it on the internet, on the telephone, by way of advertisement, a whole variety of ways. So in other words, in real substance, we do have some similar laws here, Ross, and ones, I should add, that have significant penalties. We do read that in the US case that under each each of the charges, if the defendant is found guilty, there could be, for example, imprisonment of up to 20 years. Our laws here have imprisonment of up to 15 years.
So in other words, they're fairly steep laws. But is this also a lesson to those people in Australia right now raising significant amounts of venture capital, because there's a lot of it going on right now, everybody's having a go at a startup, to be very conscious of the claims they're making about their products, of the claims that they're making to investors? Because if found to have lied or to have somehow exaggerated the claims of your product, it could very well lead you down the same sort of path that these defendants are taking in the United States right now.
Ross, this is a very, very good point. For many, many years, our corporate laws have been concerned to a very high degree with ensuring the accuracy or truthfulness of statements that are made by those associated with companies, because we do not want potential investors misled. And of course, we see many cases brought both by our regulators, but I should say also, Ross, brought in terms of class actions, in other words, by private plaintiffs, where the basis of the allegation is that those associated with companies, when raising funds, made misleading statements. So it's a very important point you make about, in a sense, sending a strong message that these laws are viewed seriously here.
Professor Ian Ramsay, Director of the Melbourne University's Law School Centre for Corporate Law, I appreciate your time on the program today.
Thank you very much, Ross.